My Lady Chief Justice, my ladies, my lords of the court, I address the court on issues 8 and 9, the magnitude of the matters which you've been listening to and which are set out in all our documents. And I will turn later to the prayers. This morning, in the last 3 of the submissions from my colleagues, the question of what Mr. Chebukati was doing when Article 183 began to operate, 138 began to operate once the 34As moved from the polling stations to the constituency levels to become 34B, and then from there to the National Tallying Center. And Article 138.3 is, Article 138 is entitled, the marginal note, Procedure at Presidential Election. And sub-article 3 is, in a presidential election, paragraph C, after counting the votes in the polling stations, the Independent Electoral and Boundaries Commission shall tally and verify the count and declare the result. 138.3c. And so there are 3 steps to be taken after leaving the polling stations. They shall be tallied and verified and the result declared. And the party that is tasked with the duty of doing these 3 things is, under the Constitution, the Independent Electoral and Boundaries Commission. But as you have heard, as you have read all the documents, we saw only Mr. Chebukati doing these duties and not doing these duties as part of the commission, but by himself, together with his clerks, together with his team members, to which I will come in a moment, but not in their capacity as having any decision-making powers over the steps he was taking as the person doing tallying and verifying. Why was there not the Independent Electoral and Boundaries Commission not taking these steps by itself or through itself? And the answer to that is given by Mr. Chebukati himself, and it is in his replying affidavit, sworn on the 26th day of August 2022. And this is what he is setting out in paragraph 108. Sorry, 103. Thank you. 103. on page 10, members of the court, my apologies, to paragraph 37. And this is what Mr. Chebukati says, that the Commission, from Gazette Notice number 9540, number 155, dated 8th of August 2022, a day before the election, outlined the result pathway from the polling station to the national tallying as follows. And then he quotes the Gazette Notice, subtitle, "The Presidential Returning Officer," into brackets, Commission Chairman, Roman 1, receives Form 34As and 34B. Article 138 is reading that the form should be received by the IEBC. Roman 2 from the Gazette Notice, the Presidential Returning Officer, Commission Chairperson, verifies. And later on, again, he says, declares. Where does he get this authority from? Is from the Gazette Notice. And so that Gazette Notice is set out in his affidavit. And the Gazette Notice is reading on page 36. This Gazette Notice is in the X made, and it sets out the result paths at the National Tallying Center, which we have seen. And so we search for the authority to move away from Article 138. How did it get from IEBC to Mr. Chebukati? In exercise of the powers confirmed by Articles 88, 44 of the Constitution, Section 4 of the IEBC Act, Sections 38, 39 of the Elections Act, and Regulations 87(1)(b) of the Elections General Regulations 2012. This shift has come through these General Regulations 2012, which were amended at a different time, and brings a different receiving party. And that receiving party is the returning officer, into brackets, Commission Chairman, and the 87 itself, the regulation, is an amendment and is referred to by Mr. Chebukati. We submit that Regulation 87 and this pathway that he has put down is a repeat of Article 138(3)(c), but with one significant alteration. Instead of the IEBC receiving the votes, instead of the IEBC verifying the votes and declaring the tally and the verification, he has put his own name, the chairman. Simple submission we have that this is subsidiary legislation. The pathway which he was relying on in the Gazette Notice is void totally. The subsidiary legislation from which the Gazette notice is derived is void, as being in total conflict with not only its principal legislation, but with the Constitution itself. This is what takes the tallying and verification process away from the IEBC and took it into what was happening from the 9th of August right up to the 15th of August. And this was breaking every single national value set out in Article 10. And because this too was a checkpoint, it is widely believed, and the chairman is the first to fan this, that there is only one key checkpoint in the process of counting, and that is 34A at the polling station, close of polling, a photograph, the Keems skit, and that's the check. We have to understand that there isn't only one check. There is a second key check from the 34As to the 34Bs. There is generated 34C. And 34C is so key that it needs a second check. And who is there to do that checking? No longer the agents at the polling stations. In their place, the Constitution sets the IEBC, the 7 commissioners. And the 7 commissioners are checking the movement of the thousands of 34As into 292 or 290 of the 34Bs. And the people watching them are the 7 commissioners who are representing the people of Kenya, overlooking the process. And by shutting them out, as has been set out by numerous of the affidavits and the television itself, that those 6 were kept away from the process of verification, so that the participation of the people of Kenya over the process of establishing the will of the people was closed down. But there is even a more dangerous thing going on here, and it is this. By this amendment, there was a concentration of the entire process, both of the verification as well as the decision-making as a consequence of that tallying and verification, a concentration into only one individual. And it gave him the power, that Gazette notice, that subsidiary legislation, in violation of the Constitution itself, to take these decisions, and vested in him an asset, a power to find a result all by himself, with no check. And if such a person were an auctioneer, then he had got into his hands, if you want to be a successful auctioneer, you must have something to auction. And this, the supreme prize in our politics, in our national life, in our institutions, had come into the hands of one person. This is a danger so great that it has been the push from the beginning of this election campaign, before the election. Keep your eyes on 34A at the polling station. Anybody who questions anything after that is an agitator, a person who is out to commit violence, is a person seeking this and that and the other. These are all decoys, taking away the key information that one man is doing this, and this petition is the most important petition that we have had. It is from this bench. There are 3 counsel here who filed and were present and argued the first presidential election petition against an incumbent 25 years ago, in 1992, now 30 years ago. And we have had to move step by step, pushing from very crude checking against very crude stuffing of ballot boxes to this day, when our ballot boxes are being stuffed with a highly sophisticated other writing form. And this is not about 2 people. It's not about one person. It's not about political ambition. This is what happens when this chairman is left to do what he has carefully managed to do. And it is therefore our first prayer that this court, the Supreme Court, holds and declares that the Gazette notice and the 87 subsidiary legislation of the general regulations is null and void for being contrary to its principal legislation and constitution. This is why there are people going to people's houses at 3 a.m. and 4 a.m. But is it something so unbelievable? No, this method, how is it that every 5 years, under the chairmanship of this particular officer, we have a crisis? Let me show you another step taken by Mr. Chebukati in this election. On the 8th of August, Mr. Chebukati announced that the gubernatorial elections for the next day in Mombasa and in Kakamega were postponed. And he puts it out in a Gazette notice. Once again, we have queried whether that was a decision of the commission or of himself. And we asked the reasons. And he has set out the reasons in that same affidavit at page 25. And at page 25, he sets out why he had to do it. Sorry. And this is what he says. Paragraph 103 of that affidavit, on page 25, that despite spirited efforts by him and his whole teams, whatever they are, to have the printer replace the ballot papers urgently, it was not possible, he says, to complete all logistics in time for the elections. In the circumstances, the Commission was constrained, now he is seeking their umbrella, was constrained to postpone the gubernatorial elections in Kakamega and Mombasa, and then he gives the authority. Pursuant to Section 55B of the Elections Act and Regulation 64 of the Elections General Regulations, which allows the Commission to postpone an election in a constituency, county, or ward, quote, I've been quoting, quote, where it is impossible for an election to proceed, full stop. Then he says that the postponement was for a limited. So he has set out that it was postponed under these two sections and regulations where it is impossible for an election to proceed. So we look up section 55B of the Elections Act. Here is 55B of the Elections Act. Postponement of elections by the Commission. Section 1. The Commission may, where a date has been appointed for holding an election, postpone the election in a constituency, county, or ward for such period as it may consider necessary, where A, there is reason to believe that a serious breach of peace is likely to occur if an election is held on that date. But Mr. Chebukati says that's not the reason. B, it is impossible to conduct the elections as a result of a natural disaster or other emergencies. He hasn't said it was because of the natural disaster or other emergencies. He doesn't say they were there. C, that there has been occurrence of an electoral malpractice of such a nature and gravity as to make it impossible for an election to proceed. A, B, C. None of these were applicable, but even if they were invoked, none of them were present in fact. But see what Mr. Chebukati had done. He had lied. He said that in Section 55B, it is provided that they may postpone if it is impossible to conduct the elections, full stop. And when we look at Regulation 67, it's identical with the same conditions. Once again, he is lying. And there is not the slightest concern, for the values of Article 10 and the whole Constitution. This is two things here to watch, members of the court. Number one, that this is a person who is saying these things with impunity. This is a person who sets out the wrongdoing that he is practicing with mens rea. This is not a mistake. This is a very calculated, very calculated subversion of forethought. He plans this, does it on the last day, doesn't explain what those conditions are which make it impossible, and delays it. And then it does not matter to him that at least 2-3 million people in Mombasa County and Kakamega County have been deprived of their right to vote. That it is important, and reversing, that a presidential election has to be held on the days when the general election is held. This is how the mess that has brought 100, a full Supreme Court, here. Because this man, when you ask him these things, justifies it, knows that it is wrong, and puts it in an affidavit. And then says to us, you explain it. So, it is important not that we cannot rely on a single thing. This is a practiced artist of the destruction of our institutions, because that is what happens. He did it in 2017. He was caught. When the court ordered him to disclose more things, he disobeyed the order, never did it, and took the benefit of the continued change of circumstances, a new election, etc. And now, back again, he is here. Same person, same sort of tricks. This was in 2012 and 2013, this amendment. This man has been practicing this for 2 election cycles. And he comes here, read this affidavit. Every 2 sentences he says, I'm conscious of the importance of my work as a state organ or a state officer. I'm a practicing advocate, and my professional integrity would never allow me to do these things. I told the NSIS, I am standing up for what is right. I told the 4 commissioners, never, I don't do things like that. When people are running, the person who calls out louder, thief, thief, thief. So that this is what has been going on, and it is destroying our institutions. This case is about the democratic institutions of Kenya. And it is about how we protect those institutions and how we stop people who are attacking those institutions. We cannot do it on the streets. We do it through the institutions. We were doing it through the bar. Now the burden has come to the judiciary because of the new constitution. And we pray that that burden will be borne constantly, persistently, with courage, because when such burdens are not borne, all of us fall down, including courts. And is that something that should be, is that something that has to be spoken to, I mean spoken for, by a party who is seeking justice? And the answer, fortunately, is no. The Constitution itself gives the answer. And that is set out in Article 3(2), which says that it is the duty every person has an obligation to respect, uphold, and defend this Constitution. Defend? Armies coming from abroad don't care about our Constitution. We're not defending this Constitution against armed incursion from anywhere. That defense is from enemies within who use this type of thing. It is not unusual. The subsidiary legislation emanates, as we all know, from the institution itself. And a letter goes to the Attorney General saying, I would like to amend this. This is what I want. The Attorney General says, give us a draft. The draft comes, sent to the draftsman, legal draftsman. First draft goes to various ministries, Attorney Generals, other departments, public, to the Interior Ministry, la. So this has been done very calculatedly. Very few of us are going to read this to see it, but no one even saw it in 2017. So we have work ahead of us. And so may I turn then to the second issue that I'm coming on to submit to your ladyships and lordships, and that is sure. Thank you. Sorry, Mary. So the prayers are there. We are asking for prayers in the petition, and we respectfully request that the court looks at them and deliberates on them. But the court also has powers from other places. For example, in the Elections Act itself, under Section 80, subsection 4, the court has power. The court has power to, if there is evidence that you find, you may issue directions that the certificate is to be made out in the name of the person who has secured more votes. The second prayer we do make outside this is this, that we cannot have, whatever the outcome of this petition, we cannot have the self-discredited person who is giving false affidavits and doing all these things to be the chairperson of the IEBC or anything at all. And so we are also saying that there are two prayers in relation to this. The Article 3 of our Constitution says this. Article 3, sub-article 2. And this is at the heart, I pray, of the judgment that this Honorable Court gives. 2, any attempt to establish a government otherwise than in compliance with this Constitution is unlawful. Any attempt to establish a government otherwise than in compliance with this Constitution is unlawful. And so, in what is a 34C? A 34C is what leads to 34B, which leads to the declaration of a precedent, which is the formation of a new government. That is what was going on the 15th of August there. An attempt, and even here, right now in this court, there are people who have filed things in contravention of the saying that what is in contravention of the Constitution is correct. And right here in this, there is an attempt to establish a government otherwise than in compliance with this Constitution. It's unlawful. So, if this Honorable Court finds that Mr. Chebukati is responsible for and has committed actions and decisions which are an attempt to establish a government otherwise than in compliance with this Constitution, we pray that you make a holding that he has done such an attempt, which is a mechanism within the Constitution itself and within this election petition's four corners, and a second and another declaration that this person, pursuant to Article 33, sub-Article 2, is no longer fit to hold public office. We go further. Is it possible that we can stop it by stopping Mr. Chebukati alone and we submit? No. It doesn't matter whether Mr. Chebukati will find another Mr. Chebukati next time. We have to stop those people who do not take those steps, but who take the benefit of those steps. And those people who take the benefit of the steps which the Constitution itself says is unlawful cannot take public office on the basis of a false 34C, 34D, of a declaration made by a person who knows he's made it falsely, so that we also pray that those who seek to benefit from the wrongdoing of Mr. Chebukati are themselves caught by Article 3, sub-Article 2, and you have the powers to make the same orders, that they too are making an attempt to establish a government in Kenya otherwise than in compliance with this Constitution. And we pray that this court moves our country forward with those two steps of orders in relation to all parties benefiting and all parties carrying out this mass attack upon Kenyan democracy. Thank you.